Supreme Court, Vice Honorable Estela M. Perlas-Bernabe. Please stand for the centennial prayer for the courts.
Almighty God, we stand in your holy presence as our Supreme Judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
It is my honor to introduce to you the members of the Judicial and Bar Council. Honorable Chief Justice Alexander G. Gesmundo, ex officio chairperson representing the judiciary. Honorable Justice Jose Catral Mendoza, chairperson of the JBC Executive Committee and regular member representing the retired justices of the Supreme Court. Honorable Judge Toribio E. Ilaw Jr., regular member representing the private sector. Honorable Justice Noel Jimenez Tiham, regular member representing the academe. And Honorable Judge Franklin J. De Monteverde, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Chief Justice and ex officio chairperson of the JBC to officially open this public panel interview.
This morning's public panel interview for the position of Associate Justice is hereby declared open.
Your Honors, the candidates to be interviewed this morning are Court of Appeals Associate Justice Fernanda C. LAMPAS Peralta, Sandigan Bayan Associate Justice Geraldine Faith A. ECONG, and Court of Appeals Associate Justice Ronaldo Roberto D. Martin. Candidates, please all stand so that I can administer the oath. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview? So help you God. May we request Justice Ekong and Justice Martin to transfer to the holding room while waiting for your turns to be interviewed. Thank you. Your Honors, the first candidate to be interviewed this morning is Court of Appeals Associate Justice Fernanda C. LAMPAS Peralta. Good morning, Justice Peralta. The first to interview Justice Peralta is the Honorable Chief Justice Alexander G. Gesmundo.
Thank you, Attorney Marife. Good morning, Justice Audrey. Please be seated.
Good morning, Your Honors. I am pleased to be here.
How are you today?
Mixed emotions. I'm delighted to see Your Honors and at the same time excited and of course quite nervous.
Relax. Take a deep breath. Anyway, I have known you for quite a time because you were my former boss at the Office of the Solicitor General. So I personally know your work ethics. So I just asked one or two questions. So which I asked also the other applicants yesterday. In your personal opinion, what is the most pressing issue or concern affecting the judiciary that the Supreme Court must address, and why? And what are your recommendations if these issues are to be addressed?
Thank you, Your Honor. In my opinion, and as I see it, The most pressing issue as of this time is the proper decongestion of court dockets. Because there's the famous saying that justice delayed is justice denied. I think there should be a continuous revision of the rules of procedure because rules of procedure are a work in progress. So they must be modified or amended as demanded by the needs of the judiciary and the court users.
Since you're recommending revisions of rules, what specific rules do you recommend to be amended, revised?
May I pattern my recommendation, Your Honor, after the revised rules of procedure for small claims cases, because the revised rules, which took effect in 2016, effectively decongested first-level courts of their voluminous small claims cases. And with the implementation of the small claims cases, which also limited the appeals to higher courts, the first-level courts were able to decide almost all those small claims cases. And this is evident from the statistics gathered by the development partners of the Supreme Court.
But of course, you are aware already that the Supreme Court just this week already approved the new rules on small claims and summary procedure cases. Of course, we call that now the expedited rules.
Yes, Your Honor.
Have you examined these new rules?
Yes, Your Honor, the new rules took into consideration the amendment of the jurisdictional amount of the first-level courts. And also the time for the first-level courts to decide small claims cases was somewhat extended in certain instances. But in my opinion, there are certain aspects also of the rules of procedure which may be looked into, like limiting the appeals to the Supreme Court, so that if the lower courts have unanimous factual and legal findings, there should be a limit, and there should be a declaration that the decision of the lower courts should no longer be appealed to the Supreme Court.
So that means for cases that are tried by the first level court, appealed to the second level court, it is your recommendation that it is still appealed to the Court of Appeals. The decision of the Court of Appeals should be final.
Yes, Your Honor, if there are unanimous findings of facts and legal conclusion.
What about the Rule 45 provision? Do we get rid of that?
The Rule 45 provision may only be amended through revision by Congress, because Rule 45 is incorporated in the essential provisions of Rule 45 are provided also in the 1987 Constitution. However, Rule 45 specifies that appeals under said rule should involve only questions of law.
When you examine these newly approved rules on expedited cases, did you see anything missing there that should have been incorporated in these rules on expedited cases?
For the new rules, Your Honor, I don't see anything lacking, except that further study should be made so that appeals should not all cases should go to the Supreme Court. Appeals should be to the Supreme Court should be limited.
Did you notice that there is no provision in the new expedited rules as regards appeals after decision of the regional trial court?
If there is no provision in the amendment, then the prevailing rules under the rules of court will apply, Your Honor.
Okay, thank you very much.
Thank you very
Those
much.
are my questions.
Thank you very much, Your Honor.
Thank you, Chief Justice Gesmundo. Our next interviewer is the Honorable Judge Franklin J. de Monteverde.
Okay, thank you, Attorney Marife. Good morning, Justice.
Good morning, Your Honor.
Yeah. How are you and the CJ?
I'm sorry, Your Honor.
How are you and Chief Justice Peralta?
Chief Justice Peralta is doing fine, Your Honor. Thank you.
And what keeps him busy these days?
Your Honor, he's busy with so many things because he still finds time to give special lectures. And apart from that, he has also acquired some jobs as independent director of certain companies.
Okay, let's go first to your medical records.
Yes, Your Honor. Your Honor, may I also refer to my copy?
Yes, go ahead.
Thank you, Your Honor.
Okay. Your urinalysis shows a high RBC, red blood cells. Then your blood chemistry shows that you have FBS, SGOT, and HDL quite high. And the latest medical certificate issued to us shows that you were diagnosed to have diabetes mellitus. What can you say about this, Justice?
Those are correct diagnoses, Your Honor. So I'm taking maintenance medication, and I have a very good doctor because he can control my blood sugar level, my cholesterol level, and even my multinodular non-toxic goiter.
Are you taking insulin shots, Justice?
No, Your Honor, only oral medications.
Oral medication. And has this diabetes of yours not bothered you at all in your performance as a justice?
It does not bother me at all because I was assured by my doctor that it's not that elevated. It's sometimes on the borderline, sometimes it goes to normal level.
Okay. Now, it has been a while since you were interviewed by the council. How did you prepare for this one?
Your Honor, I studied my application, anything I can get hold into, my recent jurisprudence, recent issuances.
Okay. You have been with the Court of Appeals for 18 years, am I correct?
Yes, Your Honor.
Okay. What made you decide to apply now for the Supreme Court Associate Justice? Did you not attempt to apply for the same position when Chief Justice Peralta was still with the Supreme Court?
Thank you for the question, Your Honor. When my husband was still with the Supreme Court, and even after his retirement, it did not come into my mind to apply with the Supreme Court. First, I was contented with my job as Associate Justice of the Court of Appeals. Of course, I wanted a promotion, but my husband was then a Supreme Court Associate Justice. And even after his retirement, I saw it fit to keep my silence by helping him adjusting in his retirement life. It is only now, or specifically last February of this year, that I realized, hey, I'm already 18 years in the Court of Appeals. I was appointed in February 2004, and I think and feel that I am now ready to assume the greater tasks of an Associate Justice of the Supreme Court.
You know, and there were talks that he retired early to allow you to apply for the Supreme Court Associate Justice. What can you say about this?
There were talks, but we just kept silent. And I will just reiterate what my husband said before. He was very grateful to the president for appointing him and for giving him the opportunity to serve as Chief Justice without elaborating on any reason at all. So now I am just reiterating what he said. Thank you to the president for giving him the opportunity to be the Supreme Court as a Chief Justice. That's all, Your Honor.
Okay. You are second in seniority ranking amongst the CA justices. Tell us about your contributions and achievements to the institution, which you think are remarkable.
I have been chairperson of several committees, but as far as I can remember, the most recent is my chairmanship of the continuing legal education for lawyers and justices. And in coordination with the PhilJA, we were able to provide for the MCLE requirements of the lawyers of the Court of Appeals. I am also at present the head of the personnel committee. I was the chairperson of the raffle committee. That's as far as I can remember, Your Honor.
How about your programs and projects as president of the Supreme Court Ladies Circle? Please name a few.
Thank you, Your Honor, for asking the question, because that was the time that I enjoyed what I did as Supreme Court Ladies Circle President. First, in coordination with the Office of Administrative Services and of course the approval of the Supreme Court Chief Justice, there were seminars conducted for the benefit of the employees, for the direct benefit of the employees. And the most remarkable, I think, is the program on mental wellness. And we call that program as CJ Cares, and CARES stands for compassion. Okay, let's leave the R. Rehabilitate, educate, and save. So that is a continuing program because the employees are provided with online seminars, workshops with very famous and competent psychologists. And there were also contributions by the SCLC to those who were adversely affected by the Taal volcano eruption. There were also fun seminars like seminars on livelihood, on basic salon services. There was also a very practical seminar on disaster preparedness and responsiveness. And I think the employees enjoyed also the online rummage sale, no contact rummage sale. Thank you, Your Honor.
Okay, Justice. Let's go to your Sal M. Who manages the finances in your family?
Thank you, Your Honor. So there is a division of labor, Your Honor.
In what sense?
In the sense that for the everyday expenses, I take charge. But for other expenses, like buying property, my husband takes charge.
I understand you have several real properties. Are all of them included in your assets?
Yes, Your Honor.
All of the conjugal properties?
The conjugal properties, yes, Your Honor.
So how do you prepare your SALN? Does the Chief Justice Peralta affix his signature to the SALN that you had submitted for the past year?
To be honest about it, it's my husband who consistently prepares the SALNs. And I trust him, so I always affix my signature. Of course, I examine the contents of the SALN that he prepares.
But he's no longer with the government service, so it's your turn now to prepare for the SALN.
Yes, Your Honor, I will be doing that.
Have you not yet submitted your SALN for the year 2021?
For the year 2021, we have submitted the SALN, but considering that the requirement speaks only of SALN for the past 10 years, we submitted our SALN from 2011 to 2020, but we have already filed our SALN for 2021.
So who is the main proponent for SALN 2021? Ikaw.
The main proponent, Your Honor?
Yeah, for 2021 because you retired last year, di ba?
Yes, Your Honor. My husband also prepared the 2021 SALN.
So he's still the main filer of the SALN that you submitted,
Yes, Your Honor.
and you merely affix your signature as your spouse.
I ask questions if I have some questions.
You are not answering me correctly. For
I'm sorry.
for the year 2021, considering that the Chief Justice Peralta is no longer with the government, I believe it is your turn now to prepare and submit the SALN, unless he includes the income or the finances that he had earned until his retirement of last year. He retired March of last year, last year.
In 2021, Your Honor.
Yeah, what month was that?
March, Your
March.
Honor.
So he should still file the SALN because he still earned an income from January to March, and he received his retirement pay.
Yes, Your Honor.
So he should be included. Did you include him as a part of your SALN?
For 2021, Your Honor, yes, Your Honor.
And all of the income that he derived was also included there.
Yes, Your Honor.
Are you in the realty business, Justice?
I am not in the realty business, but my husband and siblings formed a realty business, but it's more of a family corporation.
Okay. You also have agricultural properties.
Yes, Your Honor.
And who manages these agricultural properties?
The agricultural properties in the WAG are being managed by my husband through his lawyer. But since my husband is based
So
here,
not a farmer, the one managing your agricultural farms is a lawyer?
no, the lawyer, Your Honor, assists my husband in legal matters.
Legal matters, okay. Now I have noticed that you maintain 18 kinds of guns.
I'm sorry, Your Honor.
You have 18 kinds of firearms?
Yes, Your Honor.
Why are you an enthusiast of firearms?
Actually, Your Honor, I'm not an enthusiast of firearms, but I think that's part of the hobby, of my husband. And
So
those
it's not
firearms,
not
those-
yours, but more from the Chief Justice.
yes, Your Honor.
Now let's go to your the increases. I'm interested in the increases of your salary. Huge increases on your net worth of more or less than 3 million up to more than 12 million were reflected in your salents. Can you explain the increases, particularly in 2018 and 2019?
May I refer to my records, Your Honor?
Yes, okay. Let's go first, Justice. I only have a few minutes left. Let's go over this from 2011. From 2011, you had an increase of 6.7 million in 2012. Quite a large sum. Justice, in order to save time, can you just explain in writing within the period of 5 days from today the increases from 2011 to 2012, and then from 2017 to 2018, and from 2018 to 2019?
Yes, Your Honor, I will do that.
Okay, sige. Oh, that will be all, Justice.
Thank you very much, Your Honor.
Thank you, Judge De Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tijan.
Thank you, Attorney Cuevas. Good
morning,
morning,
Your Honor.
Justice Peralta.
Good morning, Your Honor.
Good morning, Chief Justice Peralta. Can you refresh our memory on the significant judicial reforms implemented by Chief Justice Peralta during his term?
Thank you very much, Your Honor. I could remember his his usual line. I have my 10-point program. Let us follow the rules and let us be united. Now, there are 10 programs or 10 points in his program. And first, there is the implementation of the Judicial and Integrity Board. Now we have the Judicial and Integrity Board in place. Of course, the establishment of court martials. And I think that there is already a bill which is about to be approved. There is also the promotion of the welfare of the employees.
But among the judicial reforms, which do you think is more significant or more paramount as far as you're concerned?
There are many, Your Honor, but one of the most significant accomplishments of my husband is the revision of the rules of procedure in order to expedite the disposition of cases, like the rules of criminal procedure, rules on evidence, the revised rules on small claims cases.
Justice Peralta, what is your understanding of the e-court system, which is about to be fully implemented by the Supreme Court? What is your understanding?
I believe, Your Honor, that the e-court is in response to the demands of the times, because we are now having digitalization of court proceedings. And we have to give our trust in the projects of our Supreme Court, because what is sought to be achieved in the e-court system is the dispensation, speedy dispensation of justice.
Now, the e-court system in detail would include electronic filing, electronic payment, electronic raffle, electronic service of summons, electronic monitoring of cases, and digital roll. In your opinion, are there certain concerns or problems that may arise from the implementation of the e-court system, which may come from lawyers, which may come from the judges themselves, or from the public transacting with the courts?
Your Honor, before the full implementation of the e-court system, court users, lawyers, justices, and judges should be fully educated as to the system of e-court.
Is electronic filing, for example, of pleadings, are there concerns or specific problems you can think about that should be adequately addressed by the Supreme Court?
With respect to electronic filing, I think what should be addressed is the weak internet that we have.
What about electronic raffle? At one time, during our tenure together in the Court of Appeals, there was already an attempt to implement electronic raffle. Do you think that's something practical that can be done?
It can be practical, Your Honor, but again, it concerns digitalization, and the users must be fully educated as to the mechanics of electronic raffle.
Based on your experience as a justice of the appellate court, what do you see is the difference between deliberation in the Court of Appeals and deliberation in the Supreme Court when you are appointed to the Supreme Court? Will there be a marked difference, or will it be the same?
Thank you, Your Honor, for asking that question. First, in the Court of Appeals, we have many cases, but there are some cases which have simple issues which may not need face-to-face deliberation. But there is always this attachment to our draft reports that in case that there is any concern of a member of the division, deliberation face-to-face may be called by the chairperson. Sometimes we exchange notes or communicate through Viber. But with respect to the Supreme Court, I think there will be a marked change because the decisions and rulings of the Supreme Court form part of the legal system. So there's a big responsibility, and there during the time of my husband, I could see him study cases even at home because he was always preparing for deliberations. That's why I know how hard it is, how heavy the responsibility is for an associate justice of the Supreme Court to effectively perform his or her functions. So deliberations in the Supreme Court are much different from deliberations in the Court of Appeals because they really have to come up with healthy deliberations so that their decision will be sound because their decision will form part of the legal system of the Philippines.
To your recollection, what was the most difficult, the most challenging decision you made in the Court of Appeals? You decided many cases, but there must have been at least one which you consider, to your recollection, to be the most difficult or the most challenging.
Maybe not with respect to decisions, but with respect to motions filed by certain parties for my inhibition because there's a certain case resolved by my husband in the Supreme Court. Although I had a clean conscience in handling the case, and I'm not the ponente, I have to weigh the circumstances so that the faith of the public will always be there. So even if I know I don't have to inhibit, I inhibit. So
How do you react, Justice Peralta, to newspaper publications that would assail your integrity with respect to certain decisions you have made, which the public might consider unpopular?
reaction, my normal reaction is I will not like the publication, but I will just keep it to myself because that's part of the job. I should not be onion skinned. So my reaction is that the unsatisfied party must file the appropriate motion for reconsideration or whatever appropriate action there is.
Talking about the forthcoming May elections, in your opinion, are religious groups and organizations prohibited from exercising their civil and political rights, including the right to freely express their positions on politics and preferences during elections? And I'd like to place this in its proper context. For example, religious groups like El Shaddai and leaders like Apollo Kiboloy endorse Marcos Jr., and certain Catholic leaders promoted the candidacy of Vice President Roberto. Is there a constitutional right or is there a constitutional prohibition?
Your Honor, although there is the constitutional provision on the separation of the church and the state, there is also that constitutional provision on freedom of expression. So religious organizations in times of election should be given the freedom to express their preference for a certain candidate. Of course, there should be a limitation.
Justice Peralta, is there legal basis for the Supreme Court to disbar or suspend a lawyer for acts or omissions committed abroad in a foreign jurisdiction?
If the reason for the disbarment abroad, it also constitutes a ground for the disbarment of the lawyer here in the Philippines, then that lawyer may also be disbarred, Your Honor.
If a married couple in the Philippines convert to Islam, they become Muslims, can the husband, who is now a Muslim, enter into a second marriage?
If the second marriage under the Islam law is allowed,
Is the second marriage valid or is it bigamous?
Your Honor, if the second marriage was entered into when the husband has already converted into Islam, then it is my opinion that the second marriage cannot be considered as violative of any legal provision. It cannot be considered as bigamous.
What is your understanding of a non-marital child?
Okay, Your Honor. That was in the case of Aquino versus Aquino. A non-marital child is the term used by the opponente in referring to an illegitimate child, and a marital child is the term used by the opponente in referring to a legitimate child.
The term illegitimate child is in the civil code as well as in the family code, which were enacted by Congress. So when the Supreme Court changes the nomenclature, instead of using illegitimate, they called it non-marital child. Is that not, does it not amount to judicial legislation?
In my opinion, Your Honor, there is no actual judicial legislation. It's just the court's description of a legitimate child as marital and an illegitimate child as non-marital. And in my opinion also, there is no judicial legislation because the case was remanded to the trial court for the determination of filiation of the child. So the discussion in that decision may be considered as the obiter dictum, but that's my humble opinion, Your Honor.
Justice Leonan might dissent with that observation. So my last question, Justice Peralta, is you mentioned mental health. If you are in the Supreme Court, how would you monitor the mental health of judges nationwide?
There should be proper coordination with the Office of the Administrative Services, the psychologist, the court administrator. And there should also be survey among the judges if they have any suggestions regarding the continuing seminars on mental wellness. I'd like to advocate that seminars should not only be concerned with legal education, but also mental health, continuing seminars on mental health and wellness.
Will you advocate the suspension or removal of judges who are mentally handicapped or mentally deranged?
No, Your Honor, they should be given a chance to rehabilitate.
Thank you, Justice Peralta, and good luck.
Thank you very much, Your Honor.
Thank you, Justice Tiham. Our next interviewer is the Honorable Judge Toribio Ilaw Jr.
Thank you. Thank you, Attorney Marife. Yes, good morning. Justice.
Good morning, Your Honor.
Still nervous
Yes, Your Honor.
because you said that you're delighted being here. We are also delighted to see you for the first time. For me,
Thank you, Your Honor.
that's a few questions only, not because of indifference to the presence of my former boss, Chief Justice. I would like to acknowledge the presence of the Chief Justice Ronaldo Peralta, who has been a friend of mine. And because the questions which should have been my forte to ask you had already been asked by my colleagues. Arita, is there any decision penned by then Chief Justice Ronaldo Peralta that you do not agree with? Because during his incumbency with us, he kept on telling us, mas magaling sa akin yan, si Audrey, mas magaling yan. Why do you think that your husband told us that mas magaling ka sa kanya?
Maybe, Your Honor, because we have mutual trust, respect, and admiration for each other.
Me too, because I hold him with the highest esteem and respect to Justice Peralta. Maybe of taste, siguro naman, ano. No?
I'm sorry, Your Honor.
No, they're going back to the question that any decision by the then Chief Justice you do not agree with?
None, Your Honor.
Why?
Because whenever I study his decisions, the more I admire him. And he's my consultant
My
when it
mentor.
comes to penalties, criminal cases, new laws. He's my instant reviewer.
Anyway, that's obvious enough. At the rate, your nickname is Audrey.
Yes, Your Honor, but my family calls me Anday.
Anday. Why Audrey? From Fernanda, Audrey. Were you able to ask your parents why you were called Audrey? Because it reminded me of Audrey Hepburn. Hindi naman lampas dun sa Catherine Hepburn na hindi Audrey Hepburn. Favorite ba ng parents mo yan?
No, Your Honor, I was the one who invented my nickname, Audrey. But my husband calls me Anday.
Anday?
Anday.
Any meaning of this? Anday?
It comes from Fernanda.
Fernanda.
Anday.
But if he is angry, ano tawag sa'yo?
He really gets angry, Your Honor.
Good. Justice Audrey, you are the most senior among the appellate court justices who applied for this position. Would you say that you are more qualified than your colleagues?
Your Honor, when I applied for this position, I have nothing in mind except my qualifications. And I leave everything up to the sound discretion of the JBC and the appointing authority.
No less than retired Justice Angelina Gutierrez, in her recommendation, which this office received on March 14, 2022, states that, and I quote, Justice Peralta is highly qualified and most deserving to sit as a member of the High Court.
That was very flattering, Your Honor.
Does it make sense?
It makes me feel good, Your Honor. It gives me confidence.
How about the recommendation of retired Justice Callejo?
The same, Your Honor, same effect on me.
He was the one who solemnized your marriage.
Yes, Your Honor.
That was in 19 when?
1990, Your Honor.
Could you tell us the love story between you and how did you meet each other? Because Justice Dado Peralta came from UST. You're from Sambeda.
Yes, Your Honor. We met, Your Honor, in sometime in August of 1989, while I with my boss, retired Justice Agkawili, was waiting for Judge Muro because we had a hearing before Judge Muro. Judge Muro was not then around, and my husband was on a recess. So in the lobby, my boss, Justice Agkawili, met my husband, and the rest is history.
Wow. If, pasensya na, trabaho lang. All right. All right, Justice Peralta, how do you keep yourself abreast of recent developments in law and jurisprudence? Because records show that last seminar attended was in 2019. Before that, all seminars were from 1987 to 1999.
There were some seminars which were not included, and I apologize for that, Your Honor. So to keep abreast of the recent jurisprudence, I will keep on studying.
Let's go to a recent case. Sorry. How did the Supreme Court construe Section 29 of the Anti-Terror Act or the provision regarding detention without judicial warrant of arrest?
May I refer to my constitution, Your Honor, Section 29?
Yes, please. So the follow-up question is, does Section 29 be taken to mean that it constitutes an executive warrant of arrest, which is prohibited by our Constitution? You need a call from Justice, the Chief Justice.
I'm sorry, Your Honor, it's Section 29 of Article.
Of the Anti-Terror Act or the provision regarding detention without judicial warrant of arrest. This is in the case of Calleja versus Executive Secretary, DR number 25257, December 7, 2021.
It provides for the arrest without a warrant. So the provision in the Anti-Terror Act was not among those provisions repealed or invalidated by the Supreme Court. So that remains to be a valid provision, provided that the rights of the arrested person is as provided for in the Bill of Rights are observed.
All right, thank you. Let's go to
Thank you
another
very much,
case.
Honor.
Maybe in your comfort zone, being then connected with the Office of the Solicitor General. What is the role of a counsel deputized by the Office of the Solicitor General?
The role of the counsel, Your Honor.
Deputized by the OSG.
During my time, Your Honor, the public prosecutors were deputized by the OSG. And there were also counsels from the government who coordinated with the OSG in certain cases, but not private counsel.
Does it make him the counsel of record of the case?
The private counsel or it's still the Office of the Solicitor General who remains to be the main counsel of the government.
All right, please read this case of MMDA versus High Desert Stopovers Inc., GR number 213287, December 6, 2021. All right, let's go to another case, Justice Peralta. In case of a conflict between the provisions of the Muslim Code and the Family Code, which law shall prevail?
Your Honor, it depends upon the conflict involved. So if what should be the guiding, what should be the guider in determining what law should prevail are the provisions of the Constitution. So if this law violates the Constitution, then the other law, which does not violate the Constitution, must prevail.
All right, let's go over the case of Malaki versus People, GR number 221075, November 15, 2021. All right, my last and final question, Justice Peralta. If you were given 3 things to make you happy, what would this be?
May I ask some clarification, Your Honor? 3 things to make me happy with my work or?
Maybe in your personal or professional capacity.
So first, I would like to have a healthy and happy family for the rest of my life.
Okay. 1.
I would like to see less crimes committed, and that is beyond my control.
And lastly,
And something spiritual. I would like to be able to enter the kingdom of God. It's something spiritual, but that's true.
okay, thank you. That was my last and final question. And thank you for your time, preparation, and good luck to your journey.
Thank you very much.
Thank you, Judge Ilaw. The last to interview Justice Peralta is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife.
Welcome.
Good morning, Justice Audrey.
Good morning, Your Honor.
I only have few questions. Anyway, my first, I confirm the statement of Judge Ilaw that your husband has been telling everyone that you are better than him. And he has repeated that several times. So I tend to believe him. Can you confirm that, or do I have a basis for believing him?
I would like to believe, Your Honor, that we really have mutual trust, respect, and admiration for each other.
But he places you above him,
That's why I call
above his level.
him the wind beneath my wings, Your Honor. I have said this before and I'm still saying it now.
Anyway, earlier you said with respect to criminal cases, penalties, he knows better than you. But in everything else, you're better than him.
I respect
Because
his
that's
opinion.
what he is claiming.
I respect his opinion, Your Honor.
That's why I believe him also. You respect his opinion. I believe his opinion. Now I represent the retired Supreme Court justices. Chief Justice Peralta sent questionnaires, but I will not ask questions from him because You are an applicant. From Justice Ascuna, what is the most important decision ever rendered by the Philippine Supreme Court, and why is it so?
Simply, Your Honor, to me, the most important decision concerns family life. It's decision in the regarding proper guidelines in determining psychological incapacity. The family is a basic social unit. If there's a happy family in every household, I think there would not be much of a problem in our society. So the strict guidelines laid down by the Supreme Court are very important because the sanctity of the marriage should always be protected. I think that's the most important decision. Of course, there is a slight amendment in the guidelines, but still that shows that our Supreme Court values the family, the importance of family in society.
I'll be specific. You were referring to the Republic versus Molina and Republic versus Santos, and it was modified by Tan Andan. Are you referring to those cases?
Yes, Your Honor.
And do you agree with the latest interpretation on psychological incapacity in Tan Andan?
I cannot disagree with the latest interpretation because that decision already forms part of the legal system.
Personal opinion only.
Personal opinion.
Yes. I will not take it again. We will not take it again. Because even in the Supreme Court, they the justices right separate opinions, they dissent like that.
So there should be a qualification in doing away with the guideline that a psychologist or an expert is not necessary in establishing psychological incapacity. If there is abundance of evidence and if the totality of evidence shows that there is indeed psychological incapacity, then the requirement of psychological opinion may be done away with. Your Honor.
What do you think was specifically abandoned in I mean to say what was abandoned in Republic versus Santos or Molina?
The need to present an expert opinion on psychological incapacity. But in abandoning the same, there's also a provision that the totality of evidence must be considered.
Also, juridical antecedents, right?
Yes, Your Honor.
And also incurable.
Yes, Your Honor.
It's no longer required because, if it is really incurable, they would not have allowed him or her to marry again.
Yes, Your Honor. Or maybe psychological incapacity may be relative. It may apply only to certain persons.
Yes, relative. It is relative. Correct? Anyway, the appreciation of what is the most important decision is really up to, it's different from everybody. Justice Ascuna submitted one, but your answer is very good because it affects family cohesion. You have read a lot of decisions. You have been updating yourself with several decisions of the Supreme. Where would you have dissented?
What decisions, Your Honor?
You have read a lot of decisions in your life, justice as a lawyer. Where would you have dissented?
Are we referring, Your Honor, to
Supreme Court decision.
Your, Your
Okay
Honor?
lang, okay lang. Opinion lang naman.
Maybe when it comes to
You cannot think of one na okay lang. Oh.
when it comes to interpretation
Ah,
of basic provisions.
can you name one? Okay lang if you
Yes, Your
I'll go to
Honor.
another question, also by Justice Ascuna. Okay. Why are the courts entrusted with the protection of fundamental rights under the Constitution when they are not elected? It's a matter of opinion.
The courts, especially the Supreme Court, is entrusted under that constitutional provision to protect the constitutional rights of persons, because the Supreme Court has the power to promulgate rules and regulations concerning protection of constitutional rights, pleading and practice. And may I add that under the previous constitution, the 1935 and the 1973 constitutions, the power of the Supreme Court to promulgate rules was limited, can be superseded, altered, or modified by Congress. But now the Supreme Court has the power to promulgate rules. And I think that is a very effective way for the Supreme Court to dispense through justice, because how can it dispense through justice if it has no power to amend its own rules of procedure?
This is from Chief Justice Bersamin.
Thank you, Your Honor.
Are you a judicial activist or an advocate of judicial restraint? Are judicial activism and judicial restraint matters of judicial philosophy?
I suppose, Your Honor, that they are matters of judicial philosophy. And I myself can categorize myself as a judicial activist, because by the word activist, it connotes something which is not appropriate for a magistrate. And
Not,
with
not appropriate.
for me,
Okay.
because I'm not that type of person, but I stand by my own principles, but I cannot be termed as a judicial activist.
Okay. So you are not also an advocate of judicial overreach.
Again, Your Honor, I cannot categorize myself with any of those of judicial overreach or judicial activities.
Now, I'm not supposed to ask you about cases, but you mentioned the case of Aquino versus Aquino earlier, was covered. Now, in that case, the issue was on Article 922. The iron contained rule in succession. Okay, 992 of the Civil Code. However, the court said it did not, it ignored 992, but said it should be the rights, the right of representation of a judge should be governed by Article 982. So 992 is under illegitimate children or non-marital children. But they did not act on that. But the court said that it should be governed by 982. Do you agree with that? You ignore the law in issue? The law they are supposed to, for the provision of law they are supposed to interpret.
Your Honor, with all due respect to those who deliberated on the matter, I believe that the discussion there regarding the iron curtain rule, marital, non-marital children cannot squarely be applied to what was in issue, because the finding there is that there has first to be a determination of the filiation of the child. That's why
It was remanded.
the case was remanded. And I think
But before it was remanded, there was already an obiter dictum or a rule which would be binding on the court of origin. Anyway, you're not a judicial activist or an advocate of judicial office. I think this one is an example. But I will go to another question.
yes, Your Honor.
Also from Chief Justice Peralta, in your future work as an Associate Justice of the Supreme Court, you will invariably involve yourself in constitutional and judicial interpretation. We have currently several schools of thought as far as constitutional and judicial interpretation is concerned. The most common being originalism, textualism, living constitution, and pragmatism. Can you explain to the JBC the distinctions among these schools of thought?
From what?
You remember originalism, textualism, living constitution, and pragmatism. Apat.
I think those four concerns the proper interpretation and application of the Constitution. So it will be up to the justice or the justices of the Supreme Court what approach should be applied in a specific case. So if the provisions of the Constitution are clear, I think there is no need to go into those approaches, just stick to the provisions, simple provisions of the Constitution.
Personally, you are originalist, textualist, rather than a believer of a living constitution or pragmatist.
I would like to classify myself as a believer of the living Constitution, because the Constitution must address the needs of the time. So if there is a need to introduce amendments, then there's also a process providing the Constitution for the introduction of amendments.
So you also believe in judicial activism. You believe in the living constitution. You're a pragmatist. You're also a judicial activist.
Again, Your Honor, I would not like to be classified as a judicial activist. I just see to it that what is proper is the one that should be done.
Okay, no more from the justices. There is one, but you can really answer this from Justice Joey Reyes. What is a slap? I think you can answer that.
A slap suit
Yes.
concerns that's an environmental case. So if a case is filed in the trial court and that case is intended only to embarrass those advocates of preserving the environment, then that case may be dismissed as a slap suit.
No more from the retired justices, my constituents. This is from the Court Appointment Watch Network. The Court Appointment Watch Network. This will be the last question. How will the court renew confidence and assure due process in the judiciary in an age where social media is often the platform of grievances? Would you like me to repeat the question?
Yes, Your Honor.
How will the court renew confidence and assure due process in the judiciary in an age where social media is often the platform for grievances?
Thank you, Your Honor. Justices should have this sense of integrity. And in spite of the grievances done through the media, they should not be affected. So what every individual justice must do is to act in accordance with his or her conscience and just apply the Constitution and applicable law. Each justice should not be affected by the social media. That's part of the job.
That's based on the records and evidence, right?
Yes, Your Honor.
I have no more question, but the last one is I'll give you time of 1 or 2 minutes to convince the council why you should nominate you as Justice of the Supreme Court, Associate Justice of the Supreme Court.
Thank you, Your Honor. Last February of this year, I remember that I have been an Associate Justice of the Court of Appeals since February 2004, or 18 years. And prior to that, I was with the Office of the Solicitor General for more than 17 years. So if they are added together, I have been in the government for 35 years. I have done my work conscientiously, and it was only when I was preparing the requirements that I noticed, there were some complaints which did not reach me because they were immediately dismissed. And it was only then that I got to know that there were about 5, but they were filed in the years 2015, 2017, 2004. When I work, I give my all. I do it in accordance with what I believe is fair and just. So I hope that this should be taken into consideration by the Honorable Council. Thank you, Your Honor.
We will consider everything. Thank you very much, Justice. You are excused.
Thank you very much, Your Honors.
Thank you, Justice Mendoza. Thank you, Justice Lampas Peralta, and good luck po.
Justice Peralta, nakatayo. Chief Justice.
Thank you, Chief Justice Peralta.
find any broken window, you will be conspiring to be their leader.
Yes, Your Honor. As I said,
It's a metaphor.
I feel that we don't have a window for MR and we don't have a window for interim judge.
Until a decision has been promulgated, justices also change their minds.
Is it proper to reverse a decision rendered by the Supreme Court when there are new justices like yourselves joining the court?
Hear ye, hear ye, hear ye, all persons.
So what similar contributions do you intend to initiate and implement if and when you're appointed? Of course, creation and organization of more courts because these are the institutional remedies.
To be a truly independent and co-equal branch of the government, do you think that Supreme Court justices should be elected by the people?
This profession is really very important. I think they should really undergo a process which is being done by the JBC.
Justice Peralta, that will be all your excuse.
Thank you, Your Honors.
Justice ECONG is the Honorable Judge Franklin J. de Monteverde.
Thank you, Attorney Marife. Hi, Jenny. Good morning.
Good morning, Judge Frank.
Okay. This is the third time that we met through the online interview. No? Has there been a change in your credentials since the last interview?
There is no substantial change in my credentials, Your Honor, except that perhaps after the typhoon which ravaged our area, I have increased my activities in the social level.
Okay, Justice Jenny, you look well.
Thank you po.
Okay. I have no other further questions to ask of you. That was my only question. Thank you and good luck.
Thank you, Your Honor.
Thank you, Judge de Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Cuevas. Good morning, Justice. ECONG.
Good morning. Good morning po, Your Honor.
If a lawyer who is also practicing in the United States is disbarred by an American court abroad, more specifically for mishandling the settlement funds for a bodily injury settlement he received on behalf of the client. He handled the case for a client. He is a Filipino lawyer practicing in the United States. He handled the case for a client for bodily injury. And there was a settlement fund and he mishandled it. And accordingly, he was disciplined by an American court because he is also practicing in the United States. My question is, can he also be disbarred or disciplined in the Philippines because he is also a Filipino lawyer?
It is my submission, Your Honor, that it may be a basis, but the disbarment cannot be automatic. We will have to proceed against the lawyer using the rules, the Philippine rules on discipline of a lawyer. While we will recognize that the behavior of a lawyer in other jurisdictions might be persuasive, it has to be understood that an action of a lawyer would mean that he is considered as an officer of our court. And his action at the time is not as an officer of our court. But it will have an impact on his general behavior, Your Honor, and in his relation as a lawyer to a particular client, especially if the agreement with the client was here, made in the Philippines.
The client is an American client. The case is a United States case before a United States court. And there was a complaint filed by the client because he mishandled the funds that was given as settlement for the case. So he was disciplined by an American court. And it is your view that he can be disciplined here in the Philippines.
He may be disciplined here if there is a complaint filed also here for his disbarment or discipline.
Supposing there is no complaint, can the Philippine Supreme Court take judicial notice of that foreign judgment in the United States where he was found guilty or culpable?
How would the case be brought before the Supreme Court, Your Honor? Would the Supreme Court just take cognizance of it right away?
Supposing it's published and it is made available and brought to the attention of members of the court, considering that the subject person is also a practicing lawyer in the Philippines.
But the action was not made as an officer of
So you're
this court.
saying if it is a disciplinary action of a Filipino lawyer, you have to apply certain rules respecting where the act was committed?
Not in that case, Your Honor, like it would, of course, a behavior of the lawyer in and out of the courtroom might be considered to be a basis for discipline. There are several instances when the Supreme Court sanctioned or disciplined lawyers because of their actions outside of the court, like in their behavior towards even their having extramarital relationships or like that. So the court can take cognizance of those cases, but I am more worried about the court taking cognizance if there is no complainant.
Should the Supreme Court ignore or close its eyes if it has notice about the factual event of conviction of that Filipino lawyer abroad for violation of the canons of legal ethics abroad, but not in the Philippines?
Your Honor, the problem there would be our canons might differ, number one. Number two, nobody has brought, the court can take judicial notice, of course, but knowledge of media or news articles cannot be or may not be considered as judicial notice.
If the Supreme Court should finally take cognizance of that case, can that lawyer raise as a defense the risk of double jeopardy in the sense that he has already been disciplined abroad for an act committed abroad and therefore he cannot be disciplined? Can he raise that as a defense? He cannot be disciplined for the second time for the same act.
Even if we will take we will consider double jeopardy, and in this case, it shouldn't be because this is not a criminal case, but an administrative case. It still is not double jeopardy because the Supreme Court in the Philippines is a different entity or body from the disciplining authority in the United States, Your Honor.
Hypothetically, a lawyer convicted of bigamy in the United States can also be convicted for the second time for bigamy in the Philippines?
Administratively, yes, Your Honor.
Criminally, bigamy.
Oh, criminally. Was the bigamy, again, the territoriality of a criminal action would put into play there, Your Honor.
Justice Geraldine, if in a disciplinary action, if the recommended penalty is disbarment against a lawyer, in the Supreme Court, which has jurisdiction to take cognizance of it? Is it a division or the bank itself?
If it is disbarment, Your Honor, well, I'm pretty sure about dismissal of judges and justices of the lower court. It's the en-banc. So I would suppose that disbarment is also a jurisdiction of the en-banc, Your Honor.
We're talking of a lawyer, not a judge.
Yes, Your Honor. I would suppose it is also the en-banc.
All disciplinary action against lawyers should be brought before the en-banc?
No, Your Honor.
So what actions, disciplinary actions, can be brought before the division against a lawyer?
I would think that there is also a distinction between the penalty that will be meted against the lawyer.
So what is the penalty under the rules? internal rules of the Supreme Court?
Oh, this is a guess. I haven't read on the lawyers, but
But you're applying. Should you apply after you have read it?
no, Your Honor. 1 year, Your Honor.
1 year. More than, the suspension is more than 2 years or a fine exceeding 100,000 pesos. All right. If the recommended penalty is, in the case of a dismissal of a judge or disbarment of a lawyer, the suspension of any one of them for a period of more than 2 years or a fine exceeding 100,000 pesos, okay, under the internal rules.
Thank you, Your Honor.
Under the Philippine setting, Filipino citizens who have grievances find immediate recourse through social media or by going to Mr. Tulfo, isumbong mo sa Tulfo. What is the reason for this? And if you are appointed to the Supreme Court, how would you address this distorted sense of seeking immediate justice outside of the court?
I find the question complex, so I prefer to answer first the first question. The occurrence of resorting to programs similar to that of Tulfo, isumbong mo kay Tulfo and the other programs, is again the quick fix, Your Honor. The Filipino wants to have a quick fix in their problems, and if they go to programs like this, where they tell the host their problems, the host immediately acts right before their eyes, and they think that this is the solution that they can do and get right away. Social media has increased the awareness of the public in general, and it has fed on this idea of getting a quick fix. If appointed to the court, the High Court, I would suggest that there should be I believe that the court should be more responsive to the public in general by reaching out to the public using the very media that is the fad currently. So the Supreme Court will not shun or should not shun from the use of social media, and rather use this tool, because it's a very powerful tool, to gain confidence over the people and make sure that there is that delivery of justice to the public in general.
The Senate Blue Ribbon Committee is empowered to conduct investigative hearings, but there is a qualification. It should be in aid of legislation. Supposing certain business people are invited or summoned by the Senate Blue Ribbon Committee in an investigative hearing, can those people, can the respondents raise the defense that there are pending cases on the issues to be submitted or to be discussed before the Senate, which are pending before the court? In other words, can the respondents invoke the sub judice rule in Senate hearings in aid of legislation?
It is my submission, Your Honor, that precisely because these investigations are in aid of legislation, the Senate may be able to ask questions that are pending before government agencies involving the transaction that is being subject matter of investigation.
Can the
However,
Senate therefore ask questions that will go into the merits of the case which is pending before the court? In other words, it would violate the sub judice rule Can it be raised as a defense?
There are limits also to the sub judice rule, Your Honor. So at this stage, one has to determine what the questions really are and how they should be answered. When we talk of sub judice rule, it does not mean that all matters relating to the court case cannot be answered. Facts, for example, about the case can be discussed. Another is that in aid of legislation, while the Senate may conduct its investigation, there might be limits to who can hear the answers of the businessman. So they can have probably an executive session to answer the questions.
As a Sandigan Bayan Justice, Justice ECONG, what is the rule on the computation of the prescriptive period? When do you start to count the prescriptive period?
The tolling, you mean, or the running? The running. Okay. Once the crime is committed or has been discovered, the period of prescription to file the action runs. And it stops or it's stalled whenever a preliminary investigation is conducted.
What is the blameless ignorance doctrine in the computation of the prescriptive period?
Probably it would refer to the time or the period when the accused or the defendant or respondent is not aware that there is already the case that was filed, the pending investigation.
When you compute it from the date of discovery, that is
Yes.
the blameless ignorance doctrine. And my last question is, in your opinion, can President Vladimir Putin of Russia be indicted as a war criminal by the International Criminal Court, considering that the United States, Russia, and China do not recognize the jurisdiction of the ICC?
Your Honor, I am not aware if Russia has already acceded to the Rome Statute. The last time I was aware, Russia has not yet acceded to the statute. And if a nation or a state has not acceded to the Rome Statute, it does not recognize the jurisdiction of the International Criminal Court.
So they can do it with impunity, they can escape liability from prosecution as a war criminal, in your opinion?
Prosecution as a war criminal may be done, but not under the Rome Statute, Your Honor, because the Rome Statute is very clear that the state has to accede first before the Rome Statute would cover that particular state.
All right, thank you very much, Justice ECONG, and good luck.
Thank you, Your Honor.
Thank you, Justice Tiham. Our next interviewer is the Honorable Judge Toribio Ilaw Jr.
Thank you, Attorney Cuevas. Yes, good morning, Justice.
Good morning po, Your Honor.
You were previously interviewed in June 2021.
Yes, Your Honor.
Yet, how have you enhanced your candidacy for this position since your last application?
After June 2021, Your Honor, I attended seminars on e-court management and electronic case management systems online. These were seminars conducted by Singapore Court and the National Center for State Courts. After that, after the seminars, I had that other application in January. And since then, I have not made any further actions.
All right, by the way, from the records, could you explain the discrepancy in amounts between your declared cash deposits in 2020 SAL and PDS? That's 73 million in PDS, while 47 million in 2020 SAL and.
Your Honor, the SAL-N's basis is actually the cash position as of December 31 of the previous year. The cash position in the PDS is the amounts stated or found on the bank records when you got the bank certificates. So if there is a difference in the months or even just a matter of weeks, the amount would not be the same, Your Honor. It may go up or down.
All right.
The reckoning kasi is the reckoning date is different.
Okay, but you submitted the corrected SAL and written application regarding network. But simply, there has been a substantial increase of around 12.9 million in a span of 10 months.
Yes, Your Honor.
Could you explain why?
Okay, Your Honor. My husband has he has several businesses that are sole proprietorship. And so the amounts or the deposits are in a bank account under his name or jointly held. And those amounts, when collected, are deposited in the bank, the same bank account. Unlike businesses with corporations, you have a separate bank account and balances for corporations. So these amounts that are stated in the bank certificates and even in my SAL-N are amounts that include personal to us and those in that he used for business.
The name of your husband is Stanley Chona again. I remember when I asked you about why you are not using the surname of your husband, Chona. What again was your answer?
I will have all names, Your Honor.
Chona.
I will have a family name that is a name, and my name is a name. So I will be Geraldine Faith Chona, and I will have all names, no family name.
ECONG Chona. But he is not a Chona talaga.
He is, Your Honor.
Hindi naman siya Becky, basta.
No, Your Honor. When my husband is a pure Chinese, Your Honor, when his father naturalized as a Filipino citizen, the how do you call this? The Bureau of Immigration, instead of getting the surname Tan, placed the surname as middle name, and the family name of the name of his father became his family name. So it's really Tan to Na. 3 names, Tan to Na. And then Tan became the middle name, to Na. They added it together. It became Chona.
Anyway.
So, medyo nakakahiya ho, pero that's the truth.
Ba't naman nakakahiya? Ang yaman niyo. Medyo prominent na pagka-Chinese. Stanley Chona. Chu. Tan
sana ang family name.
The name of your son is who's this? Gerald Brian E. Mentuerto.
That's my eldest son, Your Honor. He's my son in my first marriage, Your Honor.
Oh, sige, na tayo din sa mga private ano. Your monthly case disposal is 1.51. Is this correct?
Yes, Your Honor. The case disposal has greatly reduced because there are no more cases to dispose, Your Honor. The Sandigan Bayan is primarily a trial court. And so, alam mo, parang because it's like a traffic road, no, where there's stop and go. And our cases have reached that point where it all went, it exited. Those who were ripe for decisions exited. So we are now left with cases that are still on trial. And our cases are not just one, but we have clusters. So one case is 16 counts, another is 10 counts. So practically, we only have about 7 clustered cases, but it totals like 70 as of today. They're still on trial stage, Your Honor. And some of it, unfortunately, there are several accused. So when we dispose of accused, for example, A, the case is decided, but there are still co-accused who just got arrested. So hindi mo madidispose po yung kaso. You still have to continue.
Because in your previous application in 2021, you declared that your monthly average disposition is 3.67.
It has gone down, Your Honor, from 20% and then slowly down because our cases that are left pending are still in the presentation of evidence for plaintiff and defendants. Those that were already submitted for decision were already disposed of earlier.
Because I heard that Sandigan Bayan justices are being discouraged to have a face-to-face hearing. That's like in the ombudsman. Even Justice Puti.
No, Your Honor. We are conducting a face-to-face hearing right now since March. Justice Martinez knows that we are conducting hearings and his special prosecutors appear personally in court.
All right, let's go to recent case of promulgated by the court. Is the defense of improper venue in a civil action for libel a waivable defense?
Your Honor, libel is a criminal case.
But improper venue in a civil action, is it waivable?
Yes, a venue improperly waived in general rule can be waived, Your Honor, if there is very clear understanding or agreement between the parties that they will file the case in a certain venue to the exclusion of other courts.
All right, please read the case of Cheng versus Judge Alaras, GR number 164845, July 13, 2021. Let's go to another case. Do the contents of a torrent's title attest to the truth or accuracy of the contents of the document? For example, deed of sale, deed of donation, which was the basis for its issuance.
No, Your Honor. The validity and the genuineness of a torrent's title applying the mirror doctrine would only refer to the contents of that title. But as to the basis of the transfer, first transfer, you can question the validity. However, if the transfer is a prior transfer, there is no more need to look into and question the issuance of the title.
Recently, the Supreme Court re-examined the Iron Curtain Rule under Article 992 of the Civil Code, which prohibits non-marital children from inheriting from their siblings for marital children as well as relatives of their father or mother. The question is, how did the Supreme Court construe or interpret Article 992?
The Supreme Court in that case said that a non-marital, in this case, the child was allowed to inherit from his ascendant, the grandparents, considering that it would be unfair for that child to be considered illegitimate. That child actually was a child of a person who died, and that child was allowed to represent the father in the matter of succession.
All right, my last and final question. But ganun ang tingin mo sa akin, Justice.
Wala ho.
Wala kang alam sa civil?
Hindi ho.
Ayaw mo lang tumingin. Sige, nakakulot yung noo mo. Medyo, tawa ka ng konti naman. Kaya ka seryoso.
Kasi nag-iisip po, sorry.
Ganun ba? Sige. Isa lang, last and final question. How young are you, Justice?
Hindi ko na alam tuloy, Your Honor, 54.
54 years old. Okay.
Question.
All right. What hobbies do you enjoy outside of your work? May hobby ka ba? Hobbies?
Aside from reading, Your Honor, I read. I surf the internet a lot.
Hobbies ba yun?
Opo. Kung nakita niyo yung mga bata ngayon, palaging nasa cellphone.
Ngayon.
Sumama na rin ako sa mga bata, nag-i-internet,
Sa mga gadgets?
Opo. Kaya ang dala ko maraming gadget ngayon, Your Honor.
Anyway, that's pala hobby mo. Okay, thank you. And then that's my last and final question.
Thank you.
Again, good luck. My regards sa mga taga-Sandigan Bayan.
Thank you, Your Honor.
Thank you, Judge Ilaw. The last to interview Justice ECONG is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good morning, Justice ECONG.
Good morning po.
I represent the retired justices of the Supreme Court, and they have submitted questions for you to answer. This is from Chief Justice Bersamin. Number one, are you a judicial activist or an advocate of judicial restraint?
I think I am more aligned to judicial activism, Your Honor.
Can you explain?
I believe that there are some gaps in the laws that need to be interpreted by the court. And precisely the court exists to make such interpretations. And it has to take into consideration certain social and cultural conditions prevalent at the time that the actual controversy arose. So the court should not be unmindful of these conditions in making its decisions.
So you are a believer in a living constitution and a pragmatist.
I am a believer of a living constitution, Your Honor, because the preamble itself says that our constitution is an expression of our ideals, and the ideals of the Filipino changes.
How about situations which the framers did not contemplate?
That's precisely why, Your Honor, we should interpret the Constitution as a living constitution, because if we are going to look at a constitution as static, not dynamic, it will never change, then we will find the Constitution not to be applicable in so many cases or instances. Sasabihin natin that this Constitution was, that the framers never thought of this situation, and therefore will come a time that the Constitution cannot be made applicable.
You mentioned earlier the case of Aquino versus Aquino. At issue there was the provisions of Article 992, which is the Iron Curtain Rule in succession. It appears that the Supreme Court 992 is under illegitimate children. Seems that the Supreme Court not it, but said that the child death or his rights should be governed by Article 982 of the Civil Code, which does not speak of illegitimate child. What can you say of that?
Well, that decision.
Yes, yeah. The issue there was on 992 under illegitimate children. Before, that mind it said it should be governed by 982, which is a very general provision.
Well, Your Honor, we have to consider that the child is not, the stigma or the impression of an illegitimate child is one who is born out of wedlock, and that the relationship, that one of his parents is or is incapacitated to marry. That's why he is illegitimate. But in this case, this condition was not present. The parents of the child were capacitated to marry, and therefore, actually, ang hindi ko na lang nakita yung he's considered supposed to be a natural child under the old nomenclature and not really an illegitimate child, because there is no existence of a marriage of the deceased parent. So I agree with Justice Leonen that that this child could not be classified together as an illegitimate child. And I think because of the situation right now, where some parents opt not to marry, and that was his contention in or written in the ponencia, there are parents who opt not to marry. Technically, these children are not really illegitimate.
Okay. Also about family matters, Supreme Court case. A is married to B. A refuses to support B. They are married. So B filed an action for support. A interposed the defense of nullity of marriage, arguing that they got married without a marriage license. can he invoke that defense?
In the decision of the Supreme Court, that kind of marriage without a marriage license and there was no cohabitation for 5 years is considered a void marriage. And because it is a void marriage, it can be attacked collaterally and can be used as a defense in that action for support.
How about for in case the one spouse marries another again during the subsistence of the first marriage? Can one invoke the defense that the first marriage was void without having the first one judicially declared a void one?
In a case decided by the Supreme Court for bigamy, Your Honor,
Yes.
the Supreme Court considered a void marriage even without the declaration of nullity by a court as a valid defense.
The court said that. The court said, can you repeat?
In a case for bigamy,
Yes.
the accused charged with bigamy can use as a defense the nullity or voidness of his first marriage, even without a court
Judicial declaration
Oo.
nullity.
declaring
Okay.
yes
So it's clear
that
now.
marriage to be void.
Yeah, thank you very much. From Justice Adolfo Astuna. What is the best decision ever rendered by the Philippine Supreme Court and why so? He has his own choice. What is the best decision for you?
Last Monday in the PJP, he said to us, he was the speaker, and you were there, Your Honors. He
Yes.
said the best decision is Elizabeth versus Dimano. So
Yeah, it's
I scrambled Republic versus
Republic
Dimano.
versus Sandiganbayan involving
Yes.
Elizabeth Dimano.
So I scrambled to look for that while he was speaking. Kasi tapos na ho kayong lahat, no? So I scrambled to look for, and after reading, I wondered why he found it to be the best decision.
Because there was a void.
I reflected and I realized why. Because that decision was, that action of the PCGG was in the interregnum when the 1973 Constitution was no longer in effect and the 1987 Constitution was not yet ratified. So what we had was so-called the executive order of Cory Aquino. And I think he is correct because at that time, supposed to be, there would have been anarchy. There is no constitution that we should follow.
Yes. What was the reasoning of the ponente, Justice Carpio?
Carpio. He said that at that time, we have to abide by the declaration on a declaration of rights and our obligations under the United Nations, Your Honor.
The international.
Yes, Your Honor. And I understood why he said it's the best.
To him, it was the best. How about in your case? What was the best decision for you?
Of course, Your Honor, it's on a personal level. The best decision for me
As
is
a landmark of position.
no on a personal level, Your
Not
Honor.
personal.
Because to me, the best decision is the decision that applied to me.
Personally.
Yes, Your Honor. And that's the decision of the Supreme Court on the Cuaranto case against me and Justice Musni.
I see.
That's the best for me, Your Honor. And it's still a landmark case.
Written by Justice De Castro.
Yes,
right?
Your Honor. Written by
Chief Justice De Castro.
Yes, Your Honor.
Okay, you have read a lot of decisions. You surf the internet. In what decision would you have dissented?
On the decision about same-sex marriage, Your Honor.
You would have dissented. What was the ruling and why are you dissenting?
The Supreme Court said, through Justice Leonen, that for now, the remedy about same-sex marriage is really legislation.
In your case, or in your view, what is your view? There is no need for legislation.
It's time to re-examine and understand concepts of sexual orientation, gender identity, Your Honor.
But in the absence of legislation, do you think the judiciary should tackle that issue?
Again, I'm a judicial activist, Your Honor.
Yes, you are. You mentioned that. Is that not a judicial overreach?
I don't think so, Your Honor.
Why?
Again, going back to
There is no law. Why will
Yes.
you touch on it?
but the marriage is a union between a man and a woman.
Yes,
And a woman can be defined differently.
that was asked by the U.S. Supreme Court.
Yeah.
By the senators in the U.S. Supreme
Yes.
and the candidate.
The woman, Your
What is a
Honor,
woman? What is your definition of a woman?
a woman can be one who is assigned sex by sex, reason of sex. A woman can be one who has the organs for reproduction and can bear a child. But a woman can also be somebody who has that nurturing attitude or capability. So there are different aspects of a woman. It may not just be physical.
So if you
That's what I'm saying. Your
were
Honor.
the ponente, you would have ruled otherwise. You would not have dismissed it.
I would probably not. Your
Not
Honor.
dismiss it. You said you are a judicial activist. You said that it is not judicial overreach. Is that not judicial legislation? What are the boundaries? What is the test?
Pardon, Your Honor. What?
You said you're a believer of judicial activism,
Okay.
but not judicial overreach. Okay? There is no law, and you will supply that. It's not that judicial legislation. Should not the remedy be legislative rather than judicial?
Sometimes, Your Honor, there is not a law, but equity can apply.
Equity.
Yes, Your Honor.
About natural law. Can it be applied?
Not the principles of natural law applies. The principle of moral law may apply as well.
Where in our laws can we read natural law?
Where?
Yes. In our body of laws. Natural law. Diba natural law is not written.
No,
not
Your Honor,
positive
but
law.
it's underlying.
Underlying.
It's an
not-
underlying law.
It's not provided.
It's the rationale. It's the reason and the connection
It is mentioned in Article 14.
in the civil
23
code.
In civil law. Oh.
Yes.
What is nolo contendere? In our law, where do you find it? Where is it provided?
No law.
Contendere.
I'm not aware, Your Honor.
You're not aware. It is used in one of our administrative agencies. Philippine Competition Act. You're not aware. No law contender.
No, Your Honor.
From Justice Brion. Oh. What is the difference between strict scrutiny and strict construction?
Strict, strict scrutiny would refer to judicial review. When
Okay.
it's a mode of judicial review when a court carefully reviews the legality or constitutionality of a law and is strict on its application.
Very literal.
And the other one is
What is strict construction?
strict construction, I guess, with your honor, would be the opposite of a liberal interpretation, your honor.
Yeah, it refers to the construction or refers to legal hermeneutics. Right? Now, strict scrutiny is a level of scrutiny in judicial review. What are the other two?
It skips my mind, your honor.
Intermediate scrutiny and rational basis review. It's all right. Justice Brion again, what is unprotected speech?
Unprotected speech.
Yes.
Unprotected speech would refer to speech that is, for example, libel is an unprotected speech. It is not
In general, it is what? In general.
it is,
You can use your own words.
yes, your honor. Unprotected speech would be not covered by the freedom of expression.
The opposite lang ng protect.
But actually, unprotected speech would be libel.
When do you avail of compelling state interest as a defense or as a position with respect to speech?
Compelling state interest. These are the tests whether the speech is protected or not, your honor. Balancing of interest.
Compelling state interest. What is content-based also, Justice? Content-based regulation and content-neutral regulation.
Content-based regulation and content-neutral. In relation to what, your honor?
We are still under this freedom of expression.
I have not.
Anyway, you read
I
the
forgot.
case of Diocese versus Bacolod. Anyway, this will be the last one from the former Chief Justice Peralta. He submitted this before his wife applied. It refers to Republic Act 11576, wherein Congress delegated to the court the adjustment of the jurisdictional amounts of the first and second level courts. Okay. What is the test to determine whether a delegation is due or undue?
There are two tests, Your Honor.
Yes.
The completeness test and the sufficiency in
Yes.
standard test.
And the sufficiency standard test, what are the requirements? There are three.
The sufficiency in standard test, which should apply in this particular Republic Act, Your Honor, would mean that there is actually there are already conditions or limitations on how the Supreme Court would apply or interpret or probably increase the jurisdiction of the lower court or the first level court. So in this case, there was that conditions that were set and that this
I'm asking generally, not with respect to this Republic Act.
in order for the standards must apply to in general to all the instances, like in this case, Your Honor, and that there are that limitations set or given by Congress.
If you want, it must state the policy, it must state the parameters, the limitations, what else? What is the last one?
The policy, the parameters, the applicability.
Can you just read on that? Will not take it against your rights.
Thank you, Your Honor.
Ano naman kayo, criminal eh.
Huwag naman sanang criminal, Your Honor.
Criminal, kaya nyo yun.
Criminal cases po, Your Honor. Hindi ako criminal.
Nahihilo na kayo. Environmental, din naman kayo. Ano?
Okay lang po, Your Honor.
Tanungin kita.
Yes, Your Honor.
Oh, this is from Justice Joey Reyes. What is a slap? What is slap? SLAPP.
Yes, Your Honor. This is a suit filed against, these are kinds of cases or suits filed against one who is or who are protecting, for example, the environment.
Very general. Pero okay lang. Okay, that will be all, Justice.
Okay, thank you, Your Honor.
Thank you, Justice Mendoza. Thank you, Justice ECONG, and good luck po.
Thank you.
Mamaya kunin na yung papeles ko sa JBC. Pwede na po ba?
Justice Ronaldo Roberto B. Martin. Good morning again, Justice Martin. You may take your seat. Yes. The first to interview Justice Martin is the Honorable Judge Franklin J. De Monteverde.
Thank you, Attorney Marife. Good morning, Justice Martin.
Magandang umaga po.
Yeah, okay. We had interviewed you before, so I will just ask you some updates on your health and case pending against you. Let's go first to the case pending against you. You have been with the Court of Appeals for 6 years, no? And in a span of 6 years, there were so many, more than 10 cases filed. Though, except for one that remains pending, the rest were dismissed. So can you enlighten us on this administrative matter number 17-01-01-CA? A
Yes,
case filed by certain William Gilani.
thank you po for the opportunity to explain that administrative case. It essentially involves a TRO case that a complainant against Oscar Moreno, then mayor or governor of CDO, was filed against Mayor Moreno. So several justices of the CDO branch or station issued a TRO in favor of Oscar Moreno, such that one or a few of its cases did not proceed. Anyway, that being said, the complainants in that action against Oscar Moreno filed actually it's an open letter, just an open letter to the Supreme Court complaining against the allowances we were receiving from the city or city government of CDO, alleging and alluding that we were somewhat compromised and biased in favor of Oscar Moreno. So it was through an open letter, and then Chief Justice Sereno took notice of it and distributed all those complaints to several justices of the Supreme Court for appropriate action. Only one proceeded to somehow had an IP number, and unfortunately it involved us. Even an incumbent Supreme Court justice was part of it, and several CDO justices. We were all 4 remaining in that administrative case. I don't have to mention them.
Yeah.
So that is the nature of the complaint. It all boils down to the fact that we were receiving allowances, which all city officials in CDO were practically receiving from the prosecutors, judges, and everywhere practically. And as of my last reckoning, I think I was informed that that case has been resolved. It was pending before Justice Leonin, but there's no finality with respect to the resolution. Justice Meloy, Executive Justice of CDO station, who is due to retire, is one of the respondents there. So I was hoping, and I think it was, we are under the impression before he retires, it will be resolved. Or the resolution.
So it has not yet been resolved.
We were under the impression that it will be resolved soonest.
Yeah, but kindly make a follow-up on this, because this may affect your chances.
I was sorry informed about that. But it all boils down to the fact that we were receiving allowances. So that's the only nature of the administrative case.
Another thing, let's shift to your medical record.
Yes, sir.
A certificate dated February 22, 22, 22222, certifies that you were and in good physical condition.
Yes, sir.
But your
Results.
record shows otherwise. Not encouraging.
I can explain.
Let me cite the yung may bypass ka, excision, gout, toffee, right knee, September. Then your iodized calcium's high, urinalysis, protein plus, blood chemistry lahat high. And yung chest x-ray mo, meron kang atheromatous aorta. Now, except for the ECG, which shows within normal limits, medyo hindi encouraging itong results na ito. Kasi, plus the fact that there is a medical recommendation which says that you have to submit a clearance, a medical from the following. You, meaning, is recommended to obtain a cardiologic, which is a heart specialist, and a nephrologic, kidney specialist clearance.
Apo.
Namely, on your SP coronary artery bypass graft with elevated bone creatinine kidney function test. This recommendation is dated March 31, 2022.
I guess by the Supreme Court Medical Officer.
Yes, yes.
Yes, sir, but I can explain. Anyway, I will undergo that soonest.
Okay.
But definitely, with respect to the bypass operation, I was asked that in my initial interview. I was bypassed on one single artery because I had and I explained it also in that interview. I have a, shall we say, defect. I produce calcium. I overproduce calcium, which was the block, which blocked my artery. Only one major artery, it just so happened. So I underwent bypass operation 13 years ago. And as far as my medical doctors are concerned, I'm always going to the nephrologist and my cardiologist every so often. I can easily go back to them, and it just so happened that during the pandemic, I was forced not to. But recently, I went back to them. So with respect to the elevated results, I hate to admit it, but I tried the keto diet, sir.
Keto diet?
Keto diet.
That good one? Is that a good?
Sir, because I lost weight. Unfortunately, diet consists of eating more fat.
Yeah.
So it elevated my LDL or lechon de leche and the others.
Sarap.
Sarap po eh. And I lost weight, sir. I lost about 5 kilograms. So, but unfortunately, the side effect is the elevated such things, such the LDL, and but I think I have stopped that about 2-3 weeks ago. But after I received that data, and I'm due to undergo another blood test, just to. But I'm confident that it will all decrease because as far as my creatinine level is concerned, it has always been elevated. And my nephrologist has told me I'm just one of the unlucky few who has such elevated creatinine levels. Perhaps he mentioned that I also exercise regularly, and such occurrence contributes to the elevation of the creatinine. So I actually have a home gym. So as far as my health is concerned, I'm confident that I'm very healthy.
Are you a diabetic, Justice? No?
No, sir. That's why I went to Quito
Pero
because
may kidney problem ka. May kidney problem.
wala rin po, sabi ng nephrologist ko, my kidney is functioning 65% given my age that is normal.
Okay. Anyway, thank you for your explanation, but you have to comply with this recommendation of Dr. Banzon
Yes, sir.
for you to submit clearances from your from your heart specialist and also from your kidney specialist.
Yes, sir.
Okay, can you submit that within 10 days from today? Oh, no.
After
The
holding
next
ko lang ho.
deliberation, before our next deliberation.
For next deliberation, sir.
Oh,
Sige po, bukas na bukas.
oh sige. Ha?
Opo.
Okay, sige.
Nephrologist and cardiologist lang naman po, no?
Oh, yung heart specialist at saka yung kidney specialist. No?
Opo.
No, cardiologist at saka nephrologist. Okay? So I have no further questions. Thank you and good luck.
Thank you po.
Thank you, Judge De Monteverde. Our next interviewer is the Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Marita. Good morning, Justice.
Morning po.
Based on your experience as a respondent of an administrative complaint, should you be appointed to the Supreme Court, what kind of reform will you introduce with respect to investigation of incumbent judges?
As far as recommendations of administrative cases are concerned, I think the fact that the JIB has been recently constituted, I think that's more than enough. But with respect to the perspective of past respondents, I think that if I may suggest that if some complaints, especially those that are not based on corruption, I hope that somehow we will be given an option not to or to respond in writing, because it really takes time away from our usual job. But of course, if we are required to do so, we have no option but to comply. But I think that with respect to corruption-based complaints, that's the only time that it's imperative for judges and justices to respond in writing.
In your opinion, should there be a cap on the period for investigating complaints, disciplinary, administrative complaints against judges? And should there be a cap as to when it should be resolved or decided by the Supreme Court?
I'm just hoping, sir, that it would be expeditious. As to the specific time, maybe if it takes more than 2 years, that's too much, because it really affects and makes the respondents more stressful as far as his existence is concerned. Like, for example, in my case, most of the administrative cases when I was still in RTC were dismissed outright. But in this particular case of mine, in the administrative case that I was involved in, I know for a fact that it only involved allowances. Nothing inherently wrong with that, but it took several years, and it was based on an open letter. So as far as putting a cap up to the duration, I don't really have a time frame, except that if it really takes years, then I guess it's too much.
In your opinion, should the Supreme Court ignore anonymous complaints? And the second part of the question is, what should be the quantum of evidence that should be accepted by the Supreme Court to pursue an investigation against an incumbent judge?
I think, sir, I must qualify. As I mentioned, if it is corruption-based, as far as that complaint is concerned, it shouldn't be ignored. But somehow, if it has something to do with the functions of the adjudicatory function of the judge or justice in relation to a particular case, which is obviously sometimes, sir, a retaliatory action on the part of the involved parties. I think much leeway should be given to the respondent judge, if ever. So, not that a complaint or anonymous complaint will be ignored or disregarded, but the complaint must be qualified. If corruption is involved, definitely it must be looked upon. So,
How old are you now, Justice Martin?
I am 57, turning 58 this October. Just.
In your opinion, based on your experience, is there lesser work in the Court of Appeals compared to that in the Supreme Court?
Lesser work. As far as work in the Court of Appeals, it's definitely not lesser. As far as in comparison to the work of the Supreme Court, I don't think so also. It's just that some are more controversial than usual. So it sometimes gives the impression that it must be resolved as soon as possible, especially controversial cases pending in the Supreme Court or even in the Court of Appeal, which is seldom controversial cases arrive in the Court of Appeal.
But it is correct to state that the deadlines in the Supreme Court are more stringent than the deadlines. Are there deadlines, by the way, in the Court of Appeals?
Yes, sir. The more, shall we say, noticeable deadline I always observe is the 1-year deadline that I must resolve a case. So as much as possible, I follow it. But I would have to admit that there was certain time that, especially when I returned from CDO to Manila, that I failed to, or I overlooked some of the cases primarily because I just inherited those cases. And it was, the time frame involved was only about a few weeks or months.
In the seniority ladder, what is your ranking now in the Court of Appeals?
I'm number 23. I'm a senior.
Senior member. And in your estimation, how many years before you can be elevated as chair of a division?
Based on my projection on who, not that I'm projecting, sir, it's just that based on my projection on the number of incumbent justice chairmen who would be retiring, so around 2 years would be maximum, sir. But I'm not looking forward to be a chairman, sir.
Justice Martin, is there such a thing as a victimless crime?
Victimless crime. Shall we say the degree of being a victim? There are certain crimes that I presuppose are the degree of extent by which a person is considered a victim.
Probably a more specific description would be an offense where there is no private offended party.
Yes, sir. I'm thinking of libel and slander, but
trespassing. Is that an example of a victimless?
There's always a victim, sir, of the owner. That's why I'm talking about the degree of culpability, or shall we say, extent by which one is victimized.
Aside from trespassing, can you mention other offenses or crimes where there is no private offended party?
That's why I'm scratching my head, sir. At the moment, I cannot think of any.
Gambling.
Well, the victim are those that would be the society whereby persons would be encouraged to indulge in gambling, especially
prostitution. What about prostitution? Is there a private offended party?
Prostitution and a private offended party. Perhaps the dignity of the woman involved, sir.
Now, a common question that we ask in the JBC is whether you are a judicial activist. Are you a judicial activist?
I would like to think that I'm more pragmatic, Your Honor. It's just, but I don't see anything
You're not
wrong.
answering the question. Are you a judicial activist?
That's why if I cannot have a middle ground, sir, I would say that I'm an activist in the sense that I'm proactive. But definitely I'm not conservative, sir.
That's a contradiction of terms. Supposing a case is brought before you, a constitutional issue, but there is no pertinent or applicable constitutional provision you can find, how would you resolve the case? Will you dismiss the case?
This is a constitutional issue, sir. I won't dismiss it outright, but I will painstakingly try to.
So in what way will you engage in judicial activism?
The only, as far as my views on nullity of marriage, sir, and petition for recognition of foreign divorce, I always err on the side of liberality. So in that sense, I consider myself, I don't consider it judicial activism, just being more proactive. But that's the stigma with respect to activism, sir. As far as I'm concerned, I don't go beyond the extent of statutory and jurisprudential parameters. I always make sure I have some legal basis in law. So, for example, can I name an example, sir? In petition for recognition of foreign divorce, I have to interject it now. It's the only sample I could think of. This Japanese divorce by agreement, I think it's essentially collusionary because it's by agreement. The problem is it how shall we say, the poor Filipino spouse, and I know the tack of the Supreme Court now is to more liberal with respect to these kinds of cases because it will be absurd to let the alien spouse remarry while the Filipino spouse is not allowed to remarry. But the point is, the Japanese divorce by agreement is essentially collusionary. So I have to think of a way to somehow get around the parameters of statutes and jurisprudence to sometimes allow, especially in my case I'm handling now.
Do you agree with the observation that judicial activists are politicians in robes?
No, sir.
Because they tend to usurp legislative powers.
No, sir.
By resorting to judicial activism,
Politicians.
to judicial legislation.
No, sir. What is prescribed is judicial legislation, but judicial activism is within the bounds or parameters of statutes and jurisprudence is allowable. So,
is it permissible for justices in the Supreme Court to interpret the Constitution in accordance with the intent of the framers of the Constitution at the time it was framed?
yes, sir. And that's primarily the problem not the problem, but the situation in petition for recognition of foreign divorce. Initially, from Van Dorn up to the last case of Republic versus Manalo, much stride have been accomplished as far as allowing recognition of foreign divorce. Initially, divorce was not even recognized here because divorce is prescribed under Article 15. So, as far as allowing the concept of divorce, especially foreign divorce, is concerned, if it is within the bounds of law, as what happens and what is happening now, that is time it is allowed. And it's not legislation, but activism. In fact, Justice Cardiwa, in his dissent in Manalo, labeled the decision in Manalo as judicial legislation. But in that particular matter, I don't agree. It's just within the bounds of activism and legislation, sir.
Is it permissible for justices or judges to fill in gaps in the law?
Yes, sir. It's in fact, in relation to earlier question, when there's a silence in the constitutional issue, such gap can be filled up by. I was supposed to answer by sourcing other sources like American statutes or American jurisprudence, which I'm not really well versed. But I guess if there's a total absence of such jurisprudence, or local statutes, it is permissible and maybe even wise to look for other sources even abroad. So,
My last question is, in what manner or under what circumstance can a judge be allowed to exercise his civil and political rights in choosing his preference for president this coming election?
I think in this age of social media, and I'm guilty of it also, I think there's nothing wrong with expressing certain standards by which I as a justice or even.
Is it okay for a justice to put a sticker in his car?
Yes, sir. Why not? It's just a sticker expressing.
Is that not a violation against restrictions against government?
Sir,
officials?
because the reason I answered yes is because it's a car and it doesn't presuppose that that sticker was placed by me outright. It may have been placed by my sons who have their own preference. And if there is a prohibition there's an absolute prohibition to place a particular sticker on the car, it would be unfair to my children, sir.
Thank you very much, Justice Martin, and good luck.
Thank you, sir.
Thank you, Justice Singham. Our next interviewer is the Honorable Judge Toribio E. Ilaw Jr.
Thank you, Attorney Maripe. Retired Justice. I remember that when I asked you whether you were related to the late Roberto Martin and the sons Miles and Melvin, because they were my contemporaries in our school. You answered that you are not related to the Martins. I said, sir, if they're from Bulacan, most probably we're related because we have relatives in Bulacan. And I was told that Justice Roberto Martin, Supreme Court Justice, was a relative of ours. And definitely, you're not related to a certain Martin Martin. Hindi po. How about now, Poco Martin? Si Carmel ang huling alam kong ano. Anyway. What have you changed since your last application? Justice Martin, you were previously interviewed for Associate Justice Supreme Court June 2021. Unfortunately, were you nominated at that time? So what now? What changed, sir? The pandemic changed me definitely, sir. So I'm more, so to say, what can I do? Courageous. I mean, seize the day. That's why I was contemplating on whether I'm reapplying, but we only live once. So that's what the pandemic taught me. Seize the day, so carpe diem. But you tapped on my list with 14 administrative cases. Yes, sir. It, mostly arising from you when you were a regional trial court presiding judge in Antipolo. Yes, sir. And you were asked by Judge De Monteverde about the present case, which is pending. In relation to the letter request of William Gilani. Yes, sir. So about what is this administrative case filed by a certain Loretta Ecleo, filed on June 20, 2029? Frankly, sir, I have no idea about these RTC cases of mine, administrative cases. The only administrative case that I recall was with respect to my supposed fraternizing with a lawyer. That's the only time I was asked to comment. And that lawyer turned out to be dead already in the given time frame that I supposedly talked to him, allegedly. That's why, as I explained during my first interview, I was handling in Antipolo 3,000 cases, sir. It was the second highest in the whole of Philippines, outlasting only by Las Piñas, Your Honor. So out of those 3,000, I angered several hundred. So the fact that I was administratively charged by just 10, 12 is, I was even considering I should have been charged more because there were certainly plenty disgruntled litigators, Your Honor. But although the only one I remember is that particular case, I don't know this Acleus, sir, and I don't know the rest because I was never asked to comment.
Yes, because remember this Ecleo, Loretta Ecleo, maybe the wife of the cult leader Ecleo.
Hindi nga po.
Surigao.
Opo.
And the reason why this accused killed his wife because of saying Ecleo.
I hope.
No, you don't remember does not ring a bell.
Doesn't ring a bell.
Loretta Ecleo. Okay. Yeah, there was no change in your monthly case disposal since your last application. Would you say that you are satisfied with your work performance, Justice?
I'm never satisfied with the work performance, sir. It just so happens that there's a constant change in the division, sir, especially with respect to the junior member and the chairman. And sometimes it all depends on the capacity or capability of the other workers, the other justices to dispose of our drafts. So, but I can say that during the pandemic, I was more or less productive. Sir.
All right, in Kalia versus Executive Secretary, individuals from various sectors of society filed their respective petitions for certiorari and for prohibition directly before the Supreme Court. Taking into consideration the doctrines of hierarchy of courts, how did the court resolve this procedural aspect of the petitions?
I'm not aware of that case, sir. Can you enlighten me as to some of the facts there? And maybe I can recall, especially if it was publicized.
This is in relation to the alleged constitutionality of the anti-terror.
Okay, yes. When you said Kalia, I was inclined to correlate it with anti-terror, but Attorney Kalia has many cases. Anyway, it's something with the anti-terror law, sir.
Yes, please.
Yes, so that was recently decided by the Supreme Court. And your question is with respect to the hierarchy of courts.
Yes.
The Supreme Court, as far as I know the decisions concerned, sir, they only nullified two provisions, Section 4 and Section 23, I think. So as far as the hierarchy of courts are concerned, I remember reading through the decision that certain factual matters need not be resolved by the court because some of the petitioners were not yet prejudiced by the law. So as far as being expectant trier of facts even, the Supreme Court is not duty bound to address those other issues.
Do you remember whether there were constitutional issues alleged?
The constitutional issue of facial challenge and transcendental importance of the question is inherent in that particular case, sir. All right, let's go to another case. How did the Supreme Court define an environmental tort? Tort, environmental tort. Tort always involves accidents and negligence. So in relation to, I presume that there's a specific case about it, but I have to admit I don't know the particular case. But if asked to venture a guess, environmental tort has something to do with an accident or an unforeseen damage brought to the environment.
Yes, this is cited in the case of Sangdakada SR versus National Power Corporation. GR number 209538, July 7, 2021. All right, my last and final question, Justice. What do you wish you could redo?
Nothing, sir.
Nothing.
Yes, sir.
So you came here for nothing? What?
Redo, meaning what happened in my past life. I mean, in my life, sir. That's the understanding of the question.
Yes.
I have certain misgivings, but to call them regrets, those mistakes and thing that's negatively happened to me, I learned from it. So I don't want to redo them all again and avoid those mistakes because I benefited from the mistakes, sir.
Thank you. Thank you for your time and effort, and good luck again.
Thank you po.
Thank you, Judge Ilaw. The last to interview Justice Martin is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Tony Maripet. I have extensively asked Justice Martin before, so I have no questions for today. Thank you very much, Justice. Your excuse.
Thank you, Justice Mendoza. Thank you, Justice Martin, and good luck. You're now excused for.
Papa-BP muna ako. Thank you po. Thank you po. Maraming salamat po.
We will resume